So today we're going to do our exclusive authorization to sell. And I'm going to go through and fill it out. Please stop with any questions you have. Okay? But this is the easy one. All right. What else? I put gift bags up front for the AOC. I lost some of their name tags around there, but their cups are in there and have their name on. Okay, cool. Thanks.
I thought you were bringing those.
I'm sorry. Okay, so we're going to start. The very beginning. This is between whoever your seller is. I'm just going to write seller in there. And here, describe property and Keller Williams. So that's easy. Second part is our address. Do the same thing again. And we're at Main Street. We're in any city. We're going to be in Baldwin County, of course, Alabama. Now, on legal description, if you have one, you can put whatever the lot number is or the unit number. Sometimes you can have a lot and a unit number. Sometimes it's a long legal description if you have pulled from the Delta computer system what it is. And if it's real long, you can write long legal in there. They generally will have paperwork on their property from when they closed on the property. And you can ask them then if you don't have their lot numbers with them. The PPIN number is a number that is specific to that property with the Baldwin County Revenue Commission's office. Does anybody use the Delta system at all to look for properties?
No.
Okay. I will give you all a link to that so you can save it on your computer. But it's a really, really good tool to have because you can put in the name or the address and it will pull up the information about the property that you are going to be listing. You can also pull up the deed there as well. It's always a really good idea to get a copy of the deed so you know the person that you're meeting with is actually the seller of the property, that it's not in their parents' name or in a trust or whatever it could be in. So you want to make sure. That site will also give you the PPIN number. And I'll get you all the link to that so you can have that. Agency is the second one. Seller acknowledges that broker has provided seller with a written disclosure entitled the Alabama Real Estate Consumer Agency Act, which is your RECAD, which you have to have signed. And they've been informed of the specific types of agency that we offer that seller. Chances are you're going to represent the seller listing their property. Chances are you may sell that yourself or someone from our office may sell it. And if you or someone within Keller Williams sells that property, you're going to be a limited consensual dual agency. That's the type of agency you will be in, limited consensual. Because that listing belongs to our company and you cannot represent a buyer on this particular listing with a listing that belongs to our company. So this is a time you would explain RECAD to them and go over it with them and let them know that there's a chance that someone from your office is going to sell this property. And chances are pretty good of that happening. So seller does authorize broker to act as a limited consensual dual agent should you sell the property yourself or someone in our company. We've got non-discrimination, of course. Federal law prohibits discrimination in sale, rental, lease, or negotiation for property to be used for housing based on race, color, religion, sex, handicap, familiar status, or national origin. They have to know that. Very, very seldom will you get somebody who says they want a certain race or a certain type of person or no gay couples or whatever. They don't want you to sell it or show it to them. I've only had that happen once in 27 years, at which point I tell them that I appreciate their time. I hope them the best and wish them the best in selling their property. But because I do not discriminate as a realtor, then I can't help them. But very seldom will you get somebody who says that they want a certain
Sorry.
person for a neighbor.
Sorry, I'm late.
You're fine. I was kind of late myself, so you're good.
Okay.
You have to have a start date and you have to have an end date. Usually, that is a 6-month period. Today's the 18th. If I'm going to work on expireds where I am pulling the new listings every day, which is what a realtor should be doing, pull the listings every day so you're familiar with the market. So you're going to see what new listings have come on the market, what listings have expired, because of course you're going to work the expireds and try to list those properties. And if you pull up a new listing and you see that that is in your sphere, or that is a house you would like to list for sale at some time, or you fall in love with it, or whatever reason there is, the first thing I'm going to do is I'm going to look and see that this house is new on the market on the 18th. It's listed with XYZ company, and I'm going to go to my day timer, and I'm going to put in 6 days, 6 months from this date. I'm going to get all the information I can on this listing, because I know that it's going to expire in 6 months. So I have in my day timer that in 6 months I'm going to watch and know that it's going to expire probably at the end of the 6th month. And I'm going to call and try to get this listing. Everybody does that. So for that reason, let's see, we got 11, 12, 6. So this would expire in May. If it's mine, I'm going to expire it in 7 months. Try to get the longest period that I can get, but I always try to get more than 6 months. If you've done your work and you've priced it right, you're only going to need a couple weeks, maybe. But I try to get my listings at 6 months, or 7 months, 7 months instead of 6 months. Here would be your list price. You write it out, and then you put the dollar amount in there. And your type of financing. Every seller will take cash. You can look at your USDA map. That's usually rural areas that allow a USDA financing. Vendor's lien would be owner financing. If your seller was going to offer owner financing, I've had very, very few of those, but generally it's cash, mortgage, FHA, or VA. Part 3 is regarding the commission. It states that we do not fix, control, recommend, or suggest commission fees or rates for services by its members, or the percentage division of commission fees between operating members and non-members. Any commission payable herein, in all cases, is negotiable between the seller and the broker. And this section is where you put in what your commission is going to be. So your seller may negotiate with you to find out what you're going to list the property for. General and standard is 6%. They may try to negotiate more. Usually when I'm asked, is my commission negotiable? And I tell them I go all the way to 10. But we're going to say, I'm going to say 6 on this one. I want to say 7, but I'm going to say 6. Initials indicate this page of this list agreement Make sure you get all the initials on the bottom of your seller. And the property address again. B is if during the existence of this agreement or any extensions thereof, the property is sold by the broker, seller, or anyone else, or if the broker produces a ready, willing, and able buyer, will be paid our commission. If within 180 days after expiration of this agreement or any extensions thereof, a sale is made to any person who was shown the property or who was presented for sale of the property, including the seller, then the broker is still going to get paid. If you have someone who's very interested in the property and they have not made an offer yet, but you think that they're going to, and your listing expires, then you want to exclude those from the sale of the property, which means if they come in after your listing expires, you're still due a commission. This doesn't happen very often at all, but the verbiage is in there for that. C is what we're going to be paying the cooperating broker. We are pretty much a 50-50 company. We have several companies that we do have a reciprocal agreement with, that we get 50% of anything we sell for them. They get 50% of anything that they sell that we have. I always put 3% in there, or 3.5% if I list for 7%, or if I did list for 70%, I should say. Number 4 is about the systems and components and fixtures. Is going to warrant that all of this is in working order. Cooling, air conditioning equipment, including window units, plumbing, electrical system, and any including appliances shall be in proper working order at closing. Exceptions would be if they knew that there was something that was not working, and you would put that in here, that they do not warrant it to be in working order, or it's not working now and they don't plan on fixing it. So you have an idea of what's going on there, and you can put that in your notes in the MLS. Number 5 is about the warranty. If they choose to furnish a warranty for the buyer or not, and they shall or shall not furnish that warranty. We're going to say he's going to. Number 5 are about all of the things. Basically, I'm not going to read through it, but it's everything that's attached. So they can't take the stove, they can't take the lighting fixtures, they can't take the drapery curtain hardware, window blinds and shades, door screens, laundry tubs, any of that kind of stuff. So if it's attached, it's staying with the house. They need to know this, but they can't take anything with them. Most sellers do, some do not. The purchase price does not include would be, I'm not going to leave the curtains in the master bedroom because they match my comforter, or the chandelier in the dining room was a gift from my great grandmother and I'm going to replace that. They can't have that. That would be put in here. On a side note, if I were to have somebody tell me that they're not leaving the living room or the dining room chandelier, I would tell them, let's change that out now. Let's not wait and let a buyer see it and want it and that become an issue. So if someone's telling you that they're going to not let lighting fixtures or something like that go with the house and that they're going to replace it with something else, I would suggest that you tell them they need to replace that now. Number 7 is the furnishing. That's if the property is being sold furnished, partially furnished, or unfurnished. So if it's a condo situation, it may be furnished or partially furnished. Regular homes, usually it's not furnished. But that's something the seller will let you know when you're there. And number 8 is our termite. Seller agrees to furnish a written Alabama infestation report issued by a bonded and licensed pest control company, disclosing the presence of any previous or active infestation by Formosan or subterranean termites, powder post beetles, wood boring beetles, dry termites, on and on and on. If active infestation or fungus is reported, treatment of the entire dwelling may be required. If property is under a current termite contract, that's what you need to find out, if it is under a current termite contract, in which case a retreat and or repair of the affected areas may be required by a buyer or a lender. Termite may also be required in effective outbuildings by a buyer or a lender. The current termite contract, if any, that's why you gotta know if there's one, shall be kept current and transferred to the buyer. If transferable, it is a buyer's expense at closing. It's important to know. If you represent the buyer is responsible for the termite. They have to pay that fee. When you get an offer on this property, it's probably gonna say, oops, my internet's unstable. It's probably gonna say seller to pay for the termite transfer. But if it's not stated in the contract, it is a buyer's expense. Then there's a section for the seller is or is not aware of any previous infestation and that the property is or is not covered.
The last statement is not on this sheet.
Pardon me?
I don't see that last statement on this one.
Which one is that?
Where it says at buyer's expense.
Yeah, if transferable at buyer's expense at closing.
What is the typical transfer fee?
It depends on what termite company you're with. There are some that can be as high as $500 or $600. So it's good to find out who their termite company is. I would say an average is about $250 or $300. But I would find out what termite company they have, and you can call them, or they can call them and let you know what that fee is to have that transferred.
Okay.
And if they will transfer it. That's the other thing. There's some termite companies that will not transfer a bond. Terminex being one of them. So you may have at that point have to go with another completely different termite company to get an additional termite contract on the house.
Okay.
But they're going to tell you right here that the property is or is not covered. Usually it's a repair. The contract, and it tells you who it's with. The coverage is with which company and when their contract expires. So the seller should have all of that information for you. And then of course the initials again on the bottom. And plug the street address in, so now it's going to show up on the top of every page. Survey and elevation certificate. The seller does or does not have a survey, or the seller does or does not have an elevation certificate. Just so you know if there is one or there is not one, because a selling agent may ask you. So you'll know they do or they do not have it. Lead-based paint is for any house built prior to 1978. In 1978, they quit doing lead-based paint. If it's built before that time, you'll need a lead-based paint disclosure from your seller. We have them anyway. They're combined with the mold disclosure, and it's part of your listing packet. This section is about your title insurance and conveyance. Here you can list the mortgages, include mortgages and amount of debt secured hereby. Sometimes they know the exact amount, sometimes they don't. It's no big deal. The title company figures this out at closing anyway. So don't sweat about this. If they don't know, leave it blank. If it comes through compliance and I'm looking at your completed listing agreement and I have nothing in here at all, I'm still going to accept you. It's going to be accepted. So don't worry if they don't have the information about their mortgage or don't want to give it to you. Some people don't. But generally they'll tell you who their mortgage company is, or they'll tell you how much they still owe on it. They will tell you if there's any liens on the property or if there's any judgments as well. 12 is all about the marketing. We're telling them this is what we're going to do for you. We're going to place it for sale. We're going to put it in the MLS. We're going to do online social media with it. It tells about the coming soon status. It's limited to predetermine the buyer until the listing is updated. We're going to take digitized photos and everything that we're going to do for them to get their property sold as far as our marketing is concerned. Some sellers will read through everything on here and want you to explain everything to them. Some sellers just ask, where do I sign? What's the listing price? What's the commission I'm being offered? Where do I sign? But some will want to read through this entire thing. 13 is our lockbox. Whether the seller does or does not allow us to place a lockbox in the house. Most do, some will not. They'll want appointment only and somebody has to be there. And whether you're going to place an electronic lockbox or a coded lockbox on the property. Some sellers have a huge problem with a coded lockbox. They don't want it. They find that the electronic lockbox, the central lock that we have, are a lot more secure. The bottom is about the one-time code. In this case, the showing agent may ask the listing agent for a one-time code to enter the property. Use of the one-time code may be a security risk. Seller will or will not agree to the use of a one-time code on the property. We have to have their permission to do a one-time code. If they balk and don't want to have the one-time code, you'll need to explain to them that that one-time code will probably be used by an appraiser. It'll be used by an inspector, whoever's going to inspect the house if the buyer asks for an inspection. And generally, they'll go ahead and allow it. If they do not, you're going to be the one that's going to go let people in. And then there's initials again. Rental information is if the property is or is not currently in a rental program. Most of the time they are not in a rental program. Sometimes they definitely will be. And if it's in a rental program, the seller authorizes the property to contact whoever their property management company is. I have a property management company, so it would say Keller Williams, Alabama Gulf Coast Property Management, and would have my cell phone number in here. So you can get an idea of who has it, you can talk to them and find out when the lease is up and all that kind of good stuff. They will also help you if you do have a property that is in fact rented to get that tenant in a good place where they're going to be willing to let you show the house whenever you need to. Number 15 is the title. The property is deeded property, or it could be Fairhope single tax colony property. Everything is pretty much the same. The taxes are calculated the same. However, if it is Fairhope single tax property, there's another step that you have to make, the Fairhope Single Tax Corporation office. We'll be having a class about Fairhope Single Tax. If you list a property before that class, all you gotta do is find me and I will help you through this step. There is a class that the buyer has to take prior to closing with the Fairhope Single Tax Corporation office. They also have an additional fee they have to pay to get their 100-year lease on this property. So deeded property, they own it, or the mortgage company owns it, I guess I could say. Fairhope Single Tax, they are leasing the property from the Fairhope Single Tax Colony office. They can sell it, they can heir it to their children should something happen. They can do everything you can do with deeded property. However, it is single tax colony corporation property. So that's important to know. 16 is the Property Owners Association. Whether the property has an HOA, it's part of a Property Owners Association, this is where this would be filled out. They will have their HOA, who their president is, and their phone number, and that's fill that out.
Where do you typically get that information? Is that
From your seller,
just
from the seller. The seller should have all of that for you. Yeah, they should know all that and have that for you. There may be a chance that the seller doesn't live in the house. They have auto draft for their HOA dues, and they don't know. So you have to find that out. But that's not hard. It's not hard at all. The bottom says, seller further agrees to pay all costs associated with attending such items or information. Seller is aware of the following assessments issued by the Property Owners Association or pending assessments which are likely to be assessed in the future. With the hurricanes that we've been having, this may come into play. That they are going to have an assessment because of the storm damage. or not. I don't know what's going on with crazy. Apologize. So if they know that there's an assessment because of the hurricane damage and everyone's being assessed a special assessment of $250, like one in the neighborhood, to repair some of the common areas or something, this is where that would be. If the seller's aware of that, he's going to have to pay that. 17 is budget earnest money. This just says they're aware that there's going to be earnest money involved in the contract, and usually that earnest money is going to be held by the selling agent's broker. So that's where the earnest money is. '18 is disclosure. He authorizes the broker and any and all cooperating brokers to disclose to prospective buyers, to the extent required by law, any defects, latent or otherwise, affecting general health and safety known to them and the seller's property disclosure statement, if applicable. Seller acknowledges that the broker and its licensee do not have the responsibility to discover latent defects in the property or to render advice on matters outside their scope of their license. We are not home inspectors. We don't know about latent defects and all that kind of stuff. We know what the seller is telling us, and that's what we have to go by. If I'm in a house and I see there's a gigantic water stain on the ceiling and I ask them if they've ever had any leaks of any kind in the house and they tell me no, I'm going to question that. I'm going to point that out. I'm going to find out what the deal is. Not everybody's honest, so just know that. 18 is about attorney fees and litigation. The suit is brought to collect the compensation provided herein, or if the broker defends any action brought against the broker by seller relating to this agreement or under any sales authority relating to this property or agreement, broker prevail, seller shall pay all costs incurred by the broker in connection with such action, including reasonable attorney fees and court fees. That is in there as a CYA. Never had to use it. Hopefully you won't have to use it either. Number 20, seller agrees that broker shall not be responsible in any manner for loss or damage of personal or real property due to vandalism, theft, freezing water pipes, or any other damage or loss whatsoever, including but not limited to personal injuries sustained on the property. Seller agrees to pay all costs incurred by broker in connection with any claim, suit, or cause of action brought against the broker relating to such loss or damage, including attorney fees and costs. This is where you remind them to put their 12-carat diamond ring away and not on their dresser when the property is being sold. Coin collections, gun collections, all that kind of good stuff. They don't need to leave that stuff out when the property is being shown, because we are not responsible for anything that could happen as a result of that. We're not going to wrap their pipes, and if we are, hopefully there'll be some compensation for that, or hopefully it's out of the goodness of your heart because that property is going to sell and you want to take good care of it. And again, initials at the bottom. 21 is seller's representation and warranty. Seller specifically represents and warrants that seller has complete authority to sell the property and convey title. That's important. I've had a listing appointment that I went on, was filling out all the paperwork, pulled the deed while I was sitting there and found out that the seller's daughter was the one trying to sell the house on the bay. She would have been caught eventually, but I'm glad I caught it before I went through all of that. So the seller is the one who can sell the property. Seller has personally reviewed this agreement, the MLS, seller property input forms, and any attached exhibits. Seller has personally filled out the seller's disclosure statement. Do not ever fill out the seller's disclosure statement. That is only for the seller to fill out and not you. If you were to fill out the seller's disclosure statement and there was some discrepancy in it, you are going to be held liable. So the disclosure statement is only to be filled out by the seller. Let's see. Seller to fill out disclosure. if required by broker, and acknowledges that all of the information and any documents relating to the description and physical condition of the property, if applicable, and which were provided by the seller are accurate and complete to the best of the seller's knowledge. Seller agrees that all information provided by seller to the broker is accurate, complete, and correct, including any and all information provided to complete this agreement. You will get sellers who are not comfortable filling out a seller's disclosure. They just won't do it. Right at the top of the seller disclosure form, seller refused to fill out and sign and upload that where the seller's disclosure goes. So if they do not want to fill it out, you cannot make them fill it out. If a buyer's agent says, I need to see the seller's disclosure, you could send her that blank form. Sometimes the seller will actually sign it and it will say they refuse to fill it out or declined to fill it out if that's a softer word for you. Number 21, seller agrees to defend, identify, and hold harmless the broker, sales associates, and any other cooperating brokers against and from any losses, damages, claims, suits of law, including court costs and attorney fees, or other costs and expenses relating to or resulting from any actual or alleged inaccuracy or incompleteness of the property information contained herein, or any other information or representations, oral or written. It's important, oral or written, provided by seller to broker at the date of this listing agreement, as well as any subsequent information provided by seller. I don't know how I feel about the oral or written in here, because if it's not written down, it never happened. So I don't know how you would be able to prove oral what they told you they're going to be held liable for. So just remember, if it's not in writing, it didn't happen. If she told you, I'm not going to let the chandelier in the dining room go with the house, and you didn't write it down, then the seller's going to, or the buyer's going to be very upset when it's not there. So make sure you get everything in writing from them. 23 is the entire agreement. It's intended to be a legal binding agreement on all parties. Seller and brokers acknowledge that except for the attachments or references to this listing agreement, there are no other agreements, promises, conditions, or understandings either expressed or implied between them, other than is specifically set herein, which goes back to it has to be in writing. Seller warrants that there are no prior agreements on this property listing, sale or otherwise, that have not been properly terminated. If you're taking over a listing from an agent that seller is not happy with, everything has been terminated from that at that time. This agreement may not be modified or amended except in writing, which may be signed by both the buyer and seller. Verse 24 is fair housing. We know all about fair housing, and we will not discriminate under any circumstances at any time. Communication, seller authorizes broker and his sales associates to contact and or send to seller advertisement material or information by U.S. mail, email, telephone, fax, internet, social media, or any SMS messages. 25 is a good time to figure out how often they want you to communicate with them and by what means. If you're telling the seller, I'm going to contact you weekly to let you know how things are going with your house, calls that I'm getting, how my advertising are going, and all that kind of good stuff. They may tell you, I prefer you to call me every 2 weeks, or I will call you when I want to update. This is a good time to find it out. Although I do suggest weekly calls to your seller to let them know what's going on. You can also find out at that time if they prefer an email, a telephone call, or just send me a text or whatever. So that helps with your communication right off the bat. 26 is for your other provisions. I would reiterate in here again, if that chandelier is not going to go with the house, or the master bedroom curtains aren't going to go with the house, or if they are leaving the bar stools or something with the house, or if they're going to take the little storage building out back, whatever they may have in here that's going to affect the sale of that property or enhance the sale of the property. That's what I would put in here. Has a place for your seller's mailing address, their phone number, work number, their signature, printed name, and the date. And then, of course, however many sellers you have in the house. And a place for your signature, your date, and a place for your name and initials on the bottom. After you do a few of these, it's easy peasy and the easiest thing to get through. Who's got questions?
I do.
Okay,
Okay, so this is not necessarily to this, but I'm wondering, do you have a preferred closing attorney that your market center likes to use? And if so, do you have a marketing disclosure that gets signed?
we don't have a marketing disclosure that gets signed. The marketing is referenced in this contract itself. If you want to do a marketing disclosure, you're more than welcome to. However, it is covered here in the marketing that we're going to do for them.
Okay.
The title company, the seller may want to close where he closed on the property when he purchased it. More than likely, the selling agent, when the contract is written, is going to put in where they want the property closed. There is a line in the purchase agreement itself that says sale of this property to be held at, and there's a place to write in what title company the buyer would like to close at. If your seller is adamant that they want to close where they purchased the property, where they can get what's called reissue credit, in other words, that title company closed them, they have their stuff on file, they're going to get a deduction in their title costs. If they close where they purchased the property, they may counter back on the purchase agreement and say, we're going to close at Alabama Land Title. I know you want to close at Southern Land Title, but we're going to close at Alabama Land Title. That's usually addressed in the purchase agreement.
Right. Okay. So there's not a particular title company that most kind of go towards. That's what I'm kind of asking, because I'm licensed in Georgia, and we have in our market center we have a particular law firm with the closing attorney that they go to, but it's not mandatory. So that's kind of what I'm asking. So no particular title company.
Yeah, we close at title companies. They have attorneys that handle the work, but we do not close at attorney's office. We close at title companies.
Right.
There are a few title companies that several of our agents use, like Alabama Land Title is one, Anchor Title is one. There's probably 3 or 4 that I find in the closing packets whenever I do compliance.
Okay, no, that's exactly what I was asking. So perfect.
Yes.
Thank you.
You're welcome. There's got to be more questions.
If the seller has someone that they've shown the house to in like a FSBO situation that they want to exclude from this contract, you just put that in additional provisions? Or?
Yes. Yes. If they've been for sale by owner, he was asking, did everybody hear what he asked? Did everyone hear the question?
Yes.
Okay, good deal. And that would be in other provisions. Additional provisions where they are excluding Jane and John Doe because they showed them the house before it was listed. What other questions do we have? Is there anything on here that you wanted to go over in further detail? Well, you all have my cell phone number. It's 251 709 1001. Again, that's 709 1001. You think of all the questions after we're done, feel free to call me. And if you all need one-on-one with this, call me. I'll set up a time where we can sit down and do it. If you are going on a listing appointment and you're nervous about it, call me. I will go with you, or we'll have your mentor, if you have a mentor, or one of our agents would be happy to go with you, but I am more than willing to help with any appointments you have, or if you feel uncomfortable with this form. My goal is to have you comfortable with every real estate form that you have to fill out. Like, you know it like the back of your hand. You have the confidence in the world when you walk into an appointment that you can fill it out and fill it out correctly. So that's my goal, and whatever I have to do to get you to that point, I'm more than willing to do.
Can you tell us or the link to the DPIN number, how to look it up?
Sure, that's Delta Computers. And when you Google that, that'll give you Delta Computers in Baldwin County. And it's the Revenue Commission.
Revenue Commission.
And I will share that, I'll share that link on our Facebook page.
Perfect. Thank you.
You're very welcome.
One more. If you're,
One more question.
if you're listing a property, say in Mobile County,
Yes.
would you use this or would you use a Mobile County?
I use the Baldwin County, and to list property in Mobile County, you have to be out of our Daphne office for starters, because our Daphne office agents can also be part of the Mobile MLS. So you have to be part of the MLS in Mobile in order to do that. I have some Mobile agents who prefer to use the Mobile forms. I'm out of production as of the 15th of last month. But if I was going to fill out a contract in Mobile, I always used my Baldwin County form, because that's one of them. Years ago, I used the Mobile.
If you're in any other county in the state of Alabama, you still can use the Baldwin County.
You can still use the Baldwin County form.
What if they insist on using some other form?
If they insist on me using another form, call me. Yeah, call me and I'll talk to them. Because this is the form we have access to. Well, we can't, we don't have access to, any other counties.
Now, if I wanted to list a house in Mobile, would I need to be a part of the Mobile Association of Realtors? Or?
Yes, our Daphne office is part of we are with the Mobile Board. We're with the Baldwin Board, we're also with the Mobile Board.
Okay.
As an agent with our company, we just pay their monthly Mobile dues.
Okay.
You have to sign up with the Mobile Board with them, so you have access to their MLS.
So that's another, at least in the beginning, another $1,200 expense.
No. Our company is a member of the board
Okay.
in Mobile. So how that works, if our company is a member of the board, that means that our agents are able to be part of that board as well. So what we do is we're just signing up with the Mobile Board, we start paying our monthly dues, 36 or 38, I can't remember what it is. Yeah, they'll pay the $1,200.
But you can sell property with any county, right?
You can.
Without being part of that association.
It's just listed properties there. And you have to be out of our Daphne office. Our Orange, this office isn't affiliated with the Mobile Board, just our Daphne office.
That's fine.